Sudha Devi has just survived a major scare. She thought her nomination was about to be rejected because she forgot to mention that she had been holding an office of profit under the government, which she does not hold anymore. However, her lawyer explained to her that she is eligible because she does not hold the office post anymore. All she needs to do is to keep her release letter ready in case of an objection. This gives us an occasion now to look at the conditions that determine the qualifications and disqualifications of candidates aspiring to become an MP or MLA. To start with, the candidate should be constitutionally qualified as follows. She should be a citizen of India. She has to undertake the oath or affirmation under the Constitution of India before the person specified by the ECI, as explained earlier. She should be of minimum qualifying age, which is 25 years, on the date of scrutiny of nomination papers. She should fulfill any other qualification prescribed by the Parliament. There are also a few statutory qualifications for election to the Lok Sabha or the State Legislative Assembly. For assembly seats reserved for SC/ST, the candidate should be from any of the scheduled castes or scheduled tribes in the state. For seats reserved for SC/ST in the Lok Sabha, the candidate should belong to SC/ST from anywhere in the country. The candidate should be a registered elector in any assembly constituency of the state for election to that state's legislative assembly, and anywhere in the country for election to the Lok Sabha. However, in the case of Lakshadweep parliamentary constituency reserved for ST, the candidate should be a member of any of the scheduled tribes of Lakshadweep and an elector in Lakshadweep parliamentary constituency. In the case of constituencies reserved for STs in autonomous districts of Assam, the candidate should be a member of any of the scheduled tribes in any of these autonomous districts and should be an elector from any constituency in any of these autonomous districts. In the case of Sikkim, the candidate should be an elector in Sikkim parliamentary constituency. A candidate can be constitutionally disqualified if he or she falls under the following categories: holding an office of profit under the Government of India or the government of any state, unsoundness of mind, undischarged insolvent, not being a citizen of India, acknowledged allegiance or adherence to a foreign state, other disqualifications prescribed by law made by the Parliament. There are a number of statutory disqualifications as well under the Representation of the People Act 1951 on grounds of conviction for certain offences under Section 8, commission of corrupt practices under Section 8A, dismissal from a government job due to corruption or disloyalty to the state under Section 9, contract with appropriate government for supply of goods to or for execution of any work undertaken by that government under Section 9A, holding office of managing agent, manager or secretary of a company or corporation other than a cooperative society in which appropriate government has not less than 25% share, Section 10, failure to lodge account of election expenses, Section 10A, the date for determining whether a candidate is qualified and is not disqualified is also the date fixed for scrutiny of nominations. Before we move on to the next step, let us have an overview of time limits for certain important matters relating to filing of nominations. The affidavit and the forms A and B have to be filed latest by 3 p.m. on the last day of filing of nominations. Oath has to be taken after filing nomination paper and before the date fixed for scrutiny. certified extract of electoral roll can be filed up to the time of scrutiny. If a column in the affidavit has been left blank, a fresh affidavit with all columns filled can be filed up to the time fixed for scrutiny. Security deposit should be made either before filing of nomination paper or at the time of filing of nomination paper.